The Supreme Court and this court have repeatedly held that a public official with for-cause protection from removal has a constitutionally protected property interest in her position. No. Look what they're doing here. They're saying public official. What they're doing is they're conflating traditional government employees, a secretary, a janitor, a manager. They're conflating that, and those people may have a property interest in their position, on the one hand, with principal officers subject to advice and consent of the Senate and delegated Article 2 executive branch authority. Those are two very different jobs. And this Court of Appeals is lying to us when they pretend there's no distinction. How can they have independence from the president? Who do they answer to? What branch of government do the Board of Governors of the Federal Reserve answer to? They don't answer to Congress, not once they're confirmed. They don't answer to the judiciary. They don't answer to the Article 2 executive branch president. So they're not answerable to anybody, any of the three branches of government defined by our Constitution, the only legitimate branches. That, my friends, is tyranny. When you have government officials who are not answerable to anybody, low IQ Lisa Cook is what I'm going to call her, because how could you be a PhD in economics and not know you were committing mortgage fraud? And of course, all these documents are public records available to everybody. So President Trump accordingly fired her from the Federal Reserve Board as permitted by the Federal Reserve Act, which says you can fire governors of the board for cause. Now, frankly, I don't think Trump needs cause, but he had cause, so he decided to go ahead and use it. Lisa Cook sued to keep her job, and an unelected black-robed tyrannical inferior district trial court judge appointed by Biden issued an injunction against Trump's firing, keeping Cook on the Federal Reserve. Another example of an unelected black-robed tyrannical inferior district trial court judge ordering the Article 2 executive branch elected president to delegate his executive authority, which the Constitution grants exclusively to the Article 2 executive branch president. Trump appealed that decision from the Federal District Trial Court to the Court of Appeals, got a bad panel, District of Columbia Court of Appeals, and he got, what did he get? A Biden judge, an Obama judge, and one Trump judge. And the vote went 2-1 against Trump. Both the trial court's order allowing for the injunction and the Court of Appeals' refusal to clear the injunction are nothing but progressive fascist legal word salad. They are pathetic. What's powerful in all this is the dissent by Judge Katsas, the Trump judge on the 3-judge appeals panel. That's where we're going to focus most of our efforts today, because Judge Katsas' dissent provides the clear roadmap to the Supreme Court to discard this preliminary injunction from the federal district court and allow Trump to have Lisa Cook removed from the Federal Reserve Board. When this does get to the Supreme Court, and I'm sure it's on its way there right now, I'm sure Trump is running the papers over to SCOTUS right now. There's no doubt in my mind this will be another 8-1-7-2-6-3 decision by the Supreme Court in favor of Trump. It'll make Trump, I think it's 21-0 at the Supreme Court so far. Before we jump in, on the left here, I have Lisa Cook, the mortgage fraudster currently sitting on the Federal Reserve Board. And of course, on the right, we have President Donald Trump. I'm just going to show you the judges, the unelected black-robed tyrannical inferior federal court judges that have so far been involved in this case. The trial judge, Gia Cobb, was appointed by Biden in 2021. So she's been a federal judge for 4 years, lifetime appointment. And then, of course, we have the appeals court judges. That's a 3-judge panel. That's them at the bottom. Juliana Childs, another black woman of a certain BMI. She was appointed by Obama in 2010. Bradley Garcia, appointed by Biden 2 years ago. He's been a federal judge for 2 years, Garcia. And then we have Judge Katsas, whose dissent, of course, will be the guiding map for the Supreme Court in supporting Trump and the firing of Lisa Cook. Just as an exercise in pattern recognition, would you care to guess which of these judges supported which party? Would you care to guess? If I told you it was this grouping, would that shock you? Just asking. I just ask the questions that other people are uncomfortable asking. All right, so let's take a look first. So this was the unelected black robe tyrannical inferior district trial court judge, Ayoob. Her memorandum opinion, she grants the injunction against Trump. And the main argument she makes here is that Trump has not shown cause for firing Lisa Cook. The Federal Reserve System says that the Board of Governors can only be fired for cause. Doesn't define cause. And traditionally, when cause is undefined, it's very broadly deferential to the person, to the authority finding cause. And largely argues that even if there were cause in this mortgage fraud, the mortgage fraud happened before Lisa Cook was put on the board, a couple of years before she was put on the Federal Reserve Board. And therefore, it shouldn't count because it happened before she was on the Federal Reserve Board. Does that strike anybody as an insane position? Insane. So if Lisa Cobb had robbed a bank before she was put on the Federal Reserve Board, and that wasn't discovered until after she was on the board, that wouldn't be grounds for removing her from a critical monetary position within our nation, that she's a bank robber? What if she was a murderess? That wouldn't be enough? So long as she murdered before she was raised to the Federal Reserve Governor's Board, that would be fine? That wouldn't be cause to remove her? What if she engaged in financial fraud, embezzlement, but it wasn't discovered until after she was raised to the Federal Reserve Board? That wouldn't be enough to remove her? That wouldn't be cause? It's an absolutely insane position that we got from Judge Ayoob in issuing this preliminary injunction. And it's so insane that when Trump appealed this to the Court of Appeals, who also ruled in Cook's favor, said, no, we're not gonna stay this preliminary injunction. You know what the appeals court did in their reasoning for why they were going to support Lisa Cook, low IQ Cook, against President Trump? They completely abandoned this notion of it happened before she was on the board because they can see how idiotic it is. In fact, they decided they weren't going to deal with the question of cause at all. They said, well, we don't have to deal with the question of cause because we're going to decide that Lisa Cook, who was appointed by Biden, subject to advice and consent of the Senate, confirmed by the Senate to the Federal Reserve Board, that she has a property right to that job. A property right. Now, this is an incredibly outrageous position, and it's completely in conflict with more than 100 years of Supreme Court precedent, because the Supreme Court distinguishes between low-level federal employees, a janitor, a secretary, an office manager, people who do not require, they are not principal officers of the U.S. They do not require Senate confirmation. Not the same things. And the Supreme Court has long recognized this. All right, so this is the Court of Appeals decision from yesterday. Garcia, let me get my red pen here. Garcia and Childs concurring in the majority decision. These are the Trump and Biden positions. A lot of half-truths in this decision. In this court, meaning in the Court of Appeals, the government, Trump, does not dispute that it failed to provide Cook even minimal process. And by due process, they mean notice of the allegation against her and a meaningful opportunity to respond. The government, in fact, does dispute this in every substantive sense. First of all, they gave her notice. They sent her a letter saying, you're fired. That's the notice. Second of all, it's the government's position that they do not owe her an opportunity to respond because she serves at the pleasure of the president and can be fired for cause. And the cause is indisputable. We have the public documents of the mortgage fraud. So this is a very false representation of this case by this Court of Appeals in the second sentence of their opinion. They continue, the district court thus enjoined Cook's removal, based in part on its conclusion that her removal violated the Fifth Amendment. Now, in fact, they have to say in part here because Ayoob, Judge Ayoob, trial Judge Ayoob's actual decision was almost entirely based on this question of cause. Was cause met? Not on this argument of notice and opportunity to be heard, the Fifth Amendment due process argument. But the cause argument is so obviously weak that this Court of Appeals had to eject it, eject. And now they're pretending that the trial court's real argument was all about the Fifth Amendment due process. It wasn't. By the way, it's important to keep in mind, this whole due process clause is premised on another mistaken belief. or argument. You cannot have a due process claim to something to which you are not entitled. I can't have a due process claim. Right now, outside of this hotel, there's a Ferrari parked. If that Ferrari is driven away, I don't have a due process claim. Hey, I get a notice in a hearing before you can drive that car away because I'm not entitled to that car. If the owner earlier today had let me drive it around the parking lot, I would still not have a due process claim in that Ferrari. I don't have a right to the Ferrari, even if I was temporarily allowed to use it. So this whole notion, the entire heart here of this Court of Appeals argument that Lisa Cook should stay in her job, this Fifth Amendment due process claim to notice and a hearing, is premised on the falsehood that Lisa Cook has a property interest, that she's a baroness in American government, that she has a property interest to a principal officer job in the Article 2 executive branch. And that's not right. That's not what our Constitution provides. And because, in fact, and under law and under the Constitution, she cannot have a property interest in being a principal officer of the U.S., which this court ultimately has to acknowledge, and then they just wave it away. Because she doesn't have a property interest in being a principal officer, she cannot have a due process claim. This is a complete house of cards. They write the District Court of Giacob, Judge Giacob, issued its preliminary injunction after finding that Cook was likely to succeed on two of her claims: her substantive statutory claim that she was removed without cause, and a procedural claim that she has a due process right under the Fifth Amendment to her job. The government does not dispute her due process claim is reviewable by the court. Again, this is a lie by this judge. The government does not dispute that if she had a due process claim, that hypothetical due process claim would be reviewable by a court. Every legitimate due process claim is, of course, reviewable by the courts. Yes, but Trump is saying she does not have a legitimate due process claim. Therefore, there's nothing to review. But you see how dishonestly this Court of Appeals is presenting this. The Supreme Court and this court have repeatedly held that a public official with for-cause protection from removal has a constitutionally protected property interest in her position. No. Look what they're doing here. They're saying public official. What they're doing is they're conflating traditional government employees, a secretary, a janitor, a manager. They're conflating that, and those people may have a property interest in their position, on the one hand, with principal officers subject to advice and consent of the Senate and delegated Article 2 executive branch authority. Those are two very different jobs. And this Court of Appeals is lying to us when they pretend there's no distinction. They say under those precedents, which don't apply to principal officers, Cook, who is a principal officer, has a property interest because it says she can be removed only for cause, which they're not addressing. This appellate court will say we don't need to address the cause question. But if her claimed property interest exists only because of the for cause termination provision, wouldn't you have to settle this question before you got to this question? But they just slide from that, from the for cause question, which they decide they don't want to address. They slide from that into the due process question, notice and hearing, which does not exist here. First of all, there is cause. So even if she had a property interest, the cause exists. The mortgage fraud is incontestable. So that would lose her the property interest. And then, of course, there's my also correct argument that she doesn't have a property interest in the first place because nobody can have a property interest in being a principal officer of the United States. We don't have royalty in America. And without a property interest, she is not entitled to any of this due process nonsense. The government contends that those precedents do not apply because they concern mere government employees, and that principal officers of the U.S. like Cook can never have a property interest in their position. This is the correct argument. And this Court of Appeals has to say, well, yes, the distinction between typical employees on the one hand and principal officers on the other is undoubtedly significant in certain respects, but the government's categorical position is inconsistent with the principle's underlying due process analysis, and no case supports it. No case supports it because no case has ever been stupid enough to do this. If there is no property interest and there is not in principal officers, then there is no due process analysis. There also has been no precedent. There's been no case to support walking on Mars. Consider first the longstanding focus of the due process analysis in this context. There is no due process analysis in this context of a principal officer being terminated for cause by the president. There is none. Courts ask whether the legislature has created a legitimate entitlement to continued employment. All right. Trump's argument is a constitutional argument. Article 2, under the Constitution grants all 100% of executive authority to the president, the Article 2 executive branch president. That is a constitutional principle. Congress cannot change that principle by legislation. And if they try to, the legislation is unconstitutional. You cannot compel the Article 2 president to delegate his authority against his will. No court has ever held that. So much for no case supports it. No case supports the proposition that a judge, an Article 3 judge, inferior court judge, can compel the president to delegate his authority against his will. None. Not Humphrey's executor, not Weiner, not Humphrey's Weiner, none of them. Here, the plain purpose of providing for-cause protection was to ensure that the Board of Governors and national and global markets do not serve at will and thus enjoy political independence from the president. That is the purpose. But is it a constitutionally legitimate purpose? Of course it's not. How can they have independence from the president? Who do they answer to? What branch of government do the Board of Governors of the Federal Reserve answer to? They don't answer to Congress. Not once they're confirmed. They don't answer to the judiciary. They don't answer to the Article 2 executive branch president. So they're not answerable to anybody, any of the three branches of government defined by our Constitution, the only legitimate branches. That, my friends, is tyranny. When you have government officials who are not answerable to anybody, that is tyranny. Another slick little lie they tell here. The government, Trump, offers no reason why an official would have a lesser expectation of employment based on for-cause removal protection because she's an appointed officer, even a principal officer, rather than an employee. Yes, these are constitutional principles. The Trump has offered a reason. The reason is if you order me to keep her on board, you're ordering me to delegate my constitutional authority against my will. And you don't have the authority to do that. Unelected black-robed tyrannical inferior district trial court judge Gia Cobb. And if she doesn't have the authority to do that, the Court of Appeals doesn't have the authority to affirm such a lawless order by her. Instead, the government draws on intuitions about the nature of principal officers. And it is true. The Supreme Court has held that nearly all such officers are removable at will. Well, it wasn't just intuition, was it then, you jackasses? How can you say Trump's drawing on intuition when in the next sentence you have to say, the Supreme Court agrees? That's not intuition. That's constitutional law. Because Cook's imaginary due process claim is very likely meritorious, it's non-existent. It's not meritorious. There is no need to address the meaning of for cause in the federal act. This gives the whole game away. This Court of Appeals does not want to touch the for cause issue because the for cause is so demonstrably established. There's no contesting this mortgage fraud. So they just don't want to talk about it. They got their fingers in their ears. They don't want to talk about the for cause provision. If there is no actual for cause protection, either because it's unconstitutional, compelling the president to delegate authority against his will, or it's obliterated because the cause exists, then there is no due process claim. You cannot get to the due process argument until you address this, and they refuse to address the for clause issue. And then they get to the other firing cases. The government relies primarily on the Supreme Court's orders in Trump versus Wilcox and Trump v. Boyle. And unlike the cases they cited, the two they found in 250 years of American history that they say supports their position from 1901 and 1903, when was Trump v. Wilcox? And when was Trump v. Boyle? Two people who were fired by Trump, and the Supreme Court upheld those firings. 2025, my friends, this year. In those cases, the Supreme Court allowed the firings of members of the National Labor Relations Board, the Merit Systems Protection Board, the Consumer Product Safety Commission. We just had the FTC firing upheld by the Supreme Court. The Supreme Court suggested that the distinct merits question in those cases, whether for-cause removal protections for the officers was constitutional, was a close question. But in every case, who did they side with? It may have been a close call, but the president wins every time, which I expect is what's going to happen here too. In that context, the court stated the government faces greater risk of harm from an order compelling the president to delegate his executive authority than a wrongfully removed officer faces from being unable to perform her statutory duties. This Court of Appeal says this case differs. First, in neither Wilcox or Boyle, nor any similar case, involved a constitutional due process claim like Cook's. Again, Cook has no due process claim. They're making it up. And now that they've made it up, that's the entire spine of their opinion here. But it has no spine. The emperor here is wearing no clothes. There is no actual due process claim. So there is no difference in the equitable calculus. The harm to the government in this case is better viewed as its inability to remove a for-cause protected official without following due process mandates that do not exist here. Second, Cook's role at the Federal Reserve differs from Wilcox and Boyle. Unlike in those cases, the government does not dispute, again this phrase, does not dispute that Federal Reserve governors are properly protected from at-will removal. That's not the same thing as concedes. This is a way of lying to you. Did the government actually say, we agree, Federal Reserve governors cannot be removed at will? Of course they did not say that. If they had said that, this court would say the government agrees that. Not the government does not dispute that. It's also clear that the Federal Reserve wields executive power in a similar manner. It is also not clear, according to this court, as Wilson and Boyle. The Supreme Court in the Wilcox case took care to note the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And this is the fault of John effing Roberts, Chief Justice of the Supreme Court. So one of the arguments that Wilcox made is they tried to panic the Supreme Court. They said, hey, Supreme Court, if you let Trump fire me, Gwynne Wilcox, from the Merit Service Protection Board, well, that means an independent agency. Well, that means Trump could fire the Federal Reserve, and that would put the markets into a panic and collapse the U.S. economy. So to avoid Trump from collapsing the U.S. economy, you have to prohibit him from firing me, the head of the Merit Service Protection Board. And the Supreme Court said, no, we're going to let him fire you, but we're going to assure the markets that we'll be more protective of the Federal Reserve. This is the language they used. And of course, this is the foot in the door that this court uses to pretend that Lisa Cook should be treated differently. Even if Lisa Cook should be treated differently, even if we said, all right, this is the Federal Reserve is the exception. Here we are going to respect for-cause termination protections. The cause patently exists. The mortgage fraud is incontestable. And this is another horrific act of deception. Finally, Cook has been serving in her position continuously, despite the president's purported termination. No, it was a termination. It wasn't a purported termination. She was fired. She just kept showing up to work. It's like that guy from Office Space, right? With the red stapler. What was his name? Granting the government's request for emergency relief here would upend, not preserve the status quo. It's so feckless of these anti-Trump judges, the way they do this. A temporary restraining order is supposed to preserve the status quo, not allow for change, which is what they say they're doing here. But in every other temporary restraining order against Trump, what are these same federal courts have been doing, especially the District of Columbia Circuit? They've been forcing Trump to do things that were not the status quo, to rehire people that were fired, which I would argue is what's happening here, by the way, to spend money that was not being spent, to do things that were not currently happening. All these other TROs and preliminary injunctions are obviously, explicitly not maintaining the status quo. They're trying to force the president to do something different, to stop deportation proceedings that are already in effect, to return people to the U.S. who've already been deported. That's how the federal courts use a preliminary injunction to change the status quo when they want to attack the president. But then when they feel like it, they pretend that that's not allowed. We can't do it for Trump here because that would change the status quo. You feckless morons.